Hi everyone, welcome back. So in the last session, we learned about the rights and remedies under the Sale of Goods Act, caveat emptor, rights of unpaid seller, and so many more concepts. Knowing the law is one thing, but applying the law in confusing real life situations is what actually makes you a professional. So today there will be no long theories, no definitions. So today you are going to be the judge. So I will give you a situation. After every situation, you will pause the video and then decide who is at fault, which right or remedy applies, and what should be the legal outcome. So then we will test your legal instinct against the Sale of Goods Act. So let's step into our first case. The court is now in session. So let's begin with case 1. Rahul walks into a sports store and says, "I'm going for a professional marathon running. Give me suitable shoes." The shopkeeper gives him normal, casual shoes, which Rahul uses and injures his feet badly and later claims for compensation. Now, pause for a minute and think who is at fault, which principle applies here, and what will the court decide. So, the answer is the seller is at fault. The concept applied here is exception to caveat emptor, where fitness for buyer's purpose, what we had discussed in our previous video. And what would be the legal outcome? The buyer can of course claim for damages. So, Rahul clearly communicated his specific purpose and relied on the seller's skill. The seller failed to provide goods fit for that purpose, and hence the protection of caveat emptor does not apply and the seller will be held liable. Now, let's go to the next case. A used car dealer paints over the rust spots and sells the car to Meena. After 1 week, the rust becomes visible and the engine fails. Now you people think and tell me, is the buyer careless in this situation or is the seller dishonest? What remedy applies here? So the answer is the fault is that of the seller. The buyer is not careless here, but here the seller is dishonest. So the concept applied here is once again caveat emptor does not apply due to fraud or concealment by the seller. So what will be the legal outcome? The buyer can claim for damages or rescind the contract. So here the seller deliberately concealed a defect and the doctrine of caveat emptor does not protect dishonest sellers. Law steps in to protect the buyer in this case. Okay, now let's go to another case. A electronics dealer agrees to deliver 20 laptops to a coaching institute. Payment is made in advance. On the delivery date, the seller refuses to deliver, saying he got a better buyer. Now, can this also happen in real life? Of course, that possibilities are there. Now, you think who is at fault, which right is triggered, and what the buyer can do. Now here the answer is again the seller is at fault. Now which concept is applied here? Buyer's right. Suit for non-delivery. What will be the legal outcome? Buyer can claim damages. So therefore, once a contract of sale is formed and price is paid, refusal to deliver is breach of contract and buyer is entitled to compensation. Now, let's take up another case. An art collector agrees to buy a rare original painting from a seller. Now, the seller later refuses to deliver and offers a refund to the buyer. Now, you people think and tell me, is refund enough? Can the buyer demand the same painting? Now, the answer is, who is at fault? The seller is at fault. Which concept is applied? Suit for specific performance is applied. What is the legal outcome here? The court may order delivery of the same painting. But why? When the goods are unique and cannot be replaced, mere damages are not sufficient. The buyer can always demand actual performance of the contract, and this is what we learnt under suit for specific performance. Okay, now let's take up case 5. Imagine the seller delivers goods. Buyer gives a check. Now the check bounces, but goods are still in seller's warehouse. Now you think and tell me, is the seller powerless now? What right does the seller get? Now who is at fault in this case? The buyer is in fault in this case. What is the concept applied? Unpaid seller plus right of lien. What will be the legal outcome? Seller can retain the goods. Why? Let's understand the reasoning. Dishonor of check means price is unpaid. Seller becomes an unpaid seller and can exercise his right of lien since goods are still in his possession, and this is what we understood when we were talking about the concept of unpaid seller. Okay, now let's take up the last case, which says seller sends goods by transport. While goods are in transit, buyer becomes insolvent. Now, can the seller stop the delivery? And what right applies here? First of all, let's answer who is at fault. So, who is at fault? The buyer is at fault. Which concept is applied? Right to stoppage in transit is the concept applied here. What would be the legal outcome? The seller can, of course, stop the goods midway. Why? The law protects sellers from financial loss when the buyer becomes insolvent before receiving the goods, and this is the concept that we understood when we were understanding the concept of unpaid seller. Okay? I hope you got most of your answers correct. So, to sum up, in business, trust starts a contract but law finishes the fight. The Sale of Goods Act does not favor buyers and it does not even favor the sellers. It favors fairness. Okay, so maybe if you can write your own real life example of caveat emptor or unpaid seller from your own experience in the comments section, it will add to more connection with the law. So, see you in the next week's session where we are going to start a new chapter on partnership and LLP. Until then, please revise the concepts on Sale of Goods Act. See you and thank you.